Okay, kia ora and good afternoon everyone. Welcome again to Taupō District Council. This is the July meeting and welcome to members of the press, executive, councillors, deputy mayor and members of the public. Lovely to see you all here this afternoon. First, I'd like to be upstanding for our karakia, please, which is the values of the council and the way we operate. Tue ki te Māori o te whenua, tue ki te mana o te tangata, tue ki te pono o te araha, ki piki, ki eki, ki te tāmata, tue taikie. Thank you very much. Okay, now we have some councillors online. I believe Councillor Leonard, correct?
Yes, thank you.
Good afternoon, Kylie. Councillor Kirsty Truman, Mangakino. Oh, she's an apology. And Councillor Yvonne Westerman is online, back online. She was online before.
But she's coming.
Okay, she might join us shortly. Good as gold. Okay, could I have apology for Councillor Kirsty Truman for not being available? Do I have a mover, please? Thank you, Councillor Shepherd. Thank you, Councillor Williamson. All those in favour, please say aye. Aye. Those against? Aye. Carried. Just recognise the TV stations here today. I've allowed for filming on this important item today. Thank you. Welcome to the team that's come down from Auckland, I presume. Hamilton, somewhere. Cool. And Rotorua. Oh, nice and handy. Okay. And just remember, loud and clear into microphones will be good. The meeting will be recorded and uploaded later to the council's YouTube channel. Media are present and filming, as I've just said, and yeah, so that's all moving on. And just remember our resident at Kinloch who struggles to hear. Larry out there, Larry, hopefully you can hear us loud and clear. Welcome, Larry. Right, conflicts of interest. Any conflicts of interest pertaining to the items on the agenda today? Could I? Councillor Fletcher.
Yes, I understand that concerns have been raised regarding a perceived conflict of interest for item 5.1 with my wife being an employee of the Tūwharetō Māori Trust Board. I just wanted to address this by stating that my wife was not a part of the Tūwharetō Māori Trust Board working group, nor has she had any input in the JMA documentation, as she works in a different department and not with the resource management team. I've also personally sought advice and will declare this as a perceived conflict of interest for the record to keep my whānau safe, but also I want to make it clear that I will not be removing myself from the discussion or decision making on item 5.1. Kia ora.
Thank you, Councillor Fletcher. Councillor Lachlan.
I wish to declare that I may have a conflict of interest in respect of items 5.1 and 5.2. I'm comfortable on how I've managed any conflict with the JMA by, one, only participating at the TDC public workshop for the JMA, not participating in any JMA workshops at the Tūwharetō Māori Trust Board, and not participating in the joint working party that prepared the JMA document. I'm comfortable with how I've managed my any perceived conflict of interest, and I'll be voting as well.
Thank you, Councillor Lachlan. Those will be recorded. All right. First item.
To the chair.
Oh, Councillor Campbell.
Yeah, it's just a question for you.
Conflict.
What's a question for you, Your Worship? Given the CEO's refusal to provide legal guidance on potential conflicts of interest among councillors participating in the vote, how does this council intend to shield the decision from future judicial review or accusations of bias?
As I've told you as chair several times, Councillor Campbell, it's up to the person involved to make that call, and it's quite clear under standing orders they make the call. The council doesn't make the call for them. So, the two members have made it, their intentions clear, which is fine by me. So there's no legal requirement at all. So we will move on. Confirmation of minutes 4.1. meeting held on the 24th of June 2025. Do I have a mover for those minutes or any points of clarification of those minutes? Thank you, Councillor Lachlan. Seconded by Councillor Shepherd. Minutes are true and accurate. All those in favour, please say aye. Against? Carried. Thank you very much. Right. Moving on, confirmations of minutes which were held on 24th of June 2025. Any clarification of those minutes? No? So, happy to move, Councillor Shepherd. Thank you very much. Seconded by Councillor Taylor. All those in favour, please say aye. Against? Carried. 4.3, confirmation of minutes that were held on the 30th of June 2025. Any clarification or any points arising from those minutes? Can I have a mover, please, then? Yep, thank you, Councillor Shepherd and Deputy Mayor. All those in favour, please say aye. Those against? Carried. Okay, item 5.1, consideration of the Joint Committee recommendation, Joint Management Agreement with Tūwharetoa Māori Trust Board. I invite Sue Maver, Co-Governance Management Partner Nick Carroll, and Mr. David Ramaka, who's iwi Co-Governance Manager, to speak on this particular subject. Thank you. Thank you, team.
Tēnā koutou. To introduce this item, I was just going to summarise my paper. You've obviously already had that and all the attachments, so you'll have already read it. Essentially, the Tūwharetoa Raukawa and Te Arawa River Iwi Waikato River Act is the settlement legislation for the Waikato River between the River Iwi and the Crown. It requires the Council and the Trust Board to have a JMA, and the purpose of that JMA is to protect and restore the Waikato River for current and future generations. The legislation sets out processes and timeframes that must be complied with to develop a JMA. The legislation includes compulsory matters that the JMA must cover, which essentially require the Trust Board's involvement in council processes around matters under the RMA. So it's things like district plan changes, monitoring and enforcement, resource consent processing. This is not about removing or transferring council's decision-making powers under the RMA, but about formalising the early involvement of the Trust Board in these processes. The legislation, as you'll be aware from the workshops we've had, also provides for the inclusion of additional matters, provided both parties agree to their inclusion. Back in 2020, and again in 2024, the Council formed a joint committee and tasked that joint committee with negotiating a JMA under this legislation. They required that to be done by the 30th of June this year. Council agreed to the inclusion of certain matters, and in the negotiation, in particular, they agreed to the inclusion of Taupo waters in addition to the area around the upper Waikato River to be included, and some specified additional matters. The Joint Committee has worked through a robust process within the parameters set out in the legislation and have developed a draft JMA. The draft JMA seeks to protect and restore the health and well-being of Taupo Moana and the upper Waikato River, both for present and future generations. They've recommended that the JMA covers a number of additional matters. These were included because both of the parties agreed, and both parties felt that they would assist in achieving the purpose and shared vision in the JMA, which is to protect and restore the health and well-being of Taupo Moana and the upper Waikato River for present and future generations. The Joint Committee have proposed extending the JMA area from just covering the Waikato River and its catchment I think I identify that somewhere in the attachments, to also cover Taupō Moana. Now, Taupō Moana, as we've discussed before, is Lake Taupō, its tributaries, and part of the Waikato River to just north of Hooker Falls. They proposed for the JMA only to manage activities within that area that may affect the water. It's not all activities within that area. The Joint Committee felt the extension to Taupō Moana was important because Lake Taupō and its tributaries flow into the Waikato River and therefore have an influence on the Waikato River. They are all integrated, they all join. And if you protect one, you protect the other. Now you will note that this is an extension to the area wider than Taupō Waters, which is what you as council recommended was included in the negotiation. There are a few things that I need to make clear because there seems to be a bit of misinformation around. Firstly, this JMA is not an extension or an update of the 2009 JMA. We've talked about this quite a lot of times. They're entirely different legal agreements between two parties. They cover completely different matters, seek completely different goals, and they are under different legislation. They are separate legal agreements. Secondly, the Mayor asked the staff at the last council workshop in July to provide advice on options for consultation on the JMA. You will see that advice in my report to you. Essentially what it says is that it's meaningless to consult on mandatory matters except for providing information, because no amount of community feedback can change them. They're required under the law. In terms of consultation on additional matters, including the inclusion of Taupō Moana, the council could decide to consult on these matters. However, you'll see in my report an assessment of the legislative framework, so both the Upper River Waikato Act and the LGA, and your own significance and engagement policy shows that consultation with the community is not required prior to you making a decision. But you may make a decision other than that. Related to this, the Mayor and councillors have received community feedback correspondence from the community on the JMA in the last couple of weeks. All of this correspondence has been copied through diligence to all of the councillors because that is the audience for it. You'll see I included a summary in my report of some of that community feedback. Since that point, we've had more community feedback, and I have included an addendum to that attachment, so you've got that. Again, you should have had that through diligence. Thirdly, some of the matters in the JMA are subject to major reform by the current government, and I understand this has been an issue. Irrespective of other legislative reform, the Upper Waikato River Act legislates a settlement agreement that must be upheld. The intent of that settlement agreement is that Council and the River Iwi need to work closely together to manage activities that affect the Waikato River in order to protect and restore it. This intent will continue as a requirement regardless of legislative reform. Irrespective of that, you'll be aware that in the JMA there are provisions included to enable the amendment if legislative reform takes place. So that type of legislative reform that we're talking about is likely to be the form of the RMA. So if there are changes to the RMA, which we are expecting, then there may be changes required to the JMA. But the intent of the JMA does not change. Fourthly, the legislation requires the Council and the Trust Board to work together in a positive and constructive manner to develop and finalise a joint management agreement. It also provides a process for resolving issues where the two parties can't resolve them. This process involves parties working with the Minister for the Environment. to resolve those issues. And if after a short period of time those issues can't be resolved, and I think it's about 2 months, the Minister will then determine the issue. The Council and the Trust Board must then finalise the JMA in accordance with the Minister's decision. Now, I've outlined this just so you're aware of what the situation is if you come to a situation where the two parties can't agree. So, in summary, the Joint Committee has followed a robust process as required under the legislation to develop a JMA. And the JMA protects and restores the health and well-being of Taupō Moana and the Upper Waikato River for both present and future generations. They have done what you have asked them to do within the confines of the legislation, albeit they have recommended some changes in respect, or some extensions in respect to the area covered, but they have explained their reasons for that recommendation. They have recommended the draft JMA to both you and the Trust Board for approval. It is time now for you to consider that draft JMA.
Thank you, Sue. Next up, we have... No, David? Nick? No? No, cool. Okay.
Just here for questions.
Just here for questions. Okay. Any questions of Sue? Questions of clarification. Yep. Councillor Campbell?
Yeah, through the chair, I do have a few questions, but I'll ask a few and then move to the next if you like, rather than take it all up. First question, please. What about an option to remove the extensions or further matters and approve the JMA only on the items declared mandatory, actually mandatory? This seems to be a practicable option to me, and the rest of the matters could have been put in a separate relationship agreement to be consulted with the public, most likely. I'm just wondering why that is not one of the options presented to us.
Essentially, that's option 3, because your joint committee under the legislation has to prepare and develop the JMA. You would send it back to them and say, this is what you want them to do.
Okay, I'll just move on to the next rattle one off. For option 1, I've just got to really have to comment there that you're talking about disadvantages and advantages, and I don't think, I didn't see the disadvantage of overwhelming public opposition and agreement mentioned there. You don't have to answer that question, but that's a comment. Yeah, and I'll just ask the third one, then move on to Councillor Rankin. There are assertions in here about messages going out from the likes of I think myself and Hobson's pledge. They're factually incorrect, yet the referenced attachment 5 in this paper, I was expecting to see a list of refutations, reads more like a summary of public concerns to me. I don't know if you can answer that, but that's my observation.
The reference in attachment 5, I think, is the summary, the AI-generated summary of some of the feedback that has been received, which much of which, not all of which, but much of which was based on the newsletter from Hobson's Pledge. And some of the information, I still stand by my comment that some of the information in that newsletter is factually incorrect. And I'm happy to talk to you about that afterwards.
Well,
I've talked to some of those in my conversation just now, in terms of things like it is not an extension to the 2009 JMA. They are separate agreements. So it's not about extending the area of the 2009 JMA, the content of the 2009 JMA. It's those sorts of things. It's irrelevant whether the 2009 JMA had consultation or not. They're completely separate agreements under completely separate legislation with completely separate requirements behind them.
Councillor Rankin.
My question is, does this have any implications for land? Is there any involvement or any implication for land?
The short answer is yes. In that activity that takes place on the land can have an impact on the waterways, and the purpose of this agreement is to look after the well-being, the health of those waterways. So if I take an example of disposal of sewage, treated sewage onto land, ultimately makes its way through the water table into the waterways. So that's an example of an activity on the land that could impact on the waterways.
The implications then could be quite big.
Well, the question was,
Is
can
the land
things-
implicated?
can
And
things
you
happen on
said
the land?
yes.
Yes.
I mean, when you talk about the things you talk about, there is quite an implication then attached to that, which has never been explained in anything I've read. I just happened to pick it up on about my 5th read of something, was land involved, and I couldn't tell. I think that's a massive discrepancy in not telling us, because I wouldn't have automatically read that into what you've told us, so I'm really disappointed about that.
Well, and that's why there's a definition section in the JMA which talks about the area that is impacted. It talks not only about the waterways, but it talks about the catchments related to those waterways. And that's certainly been a point of conversation through the series of workshops that were held with Council.
Okay, so thank you, Councillor Rankin. So now that we're entering into debate, and I'll let that go forward, I'd like to move. I'd like to move option 4, that Council defers consideration. Yes, yeah, we can do. Yeah, option 4 of the draft joint management defers consideration, directs the Chief Executive to refer the matter to the incoming Council as soon as reasonably practical. My reason for this has become clear, even here this afternoon, that much of the debate has been driven by misinformation, misunderstanding, and at times deliberate disinformation. I recognise that this agreement has not been socialised enough, and I take some responsibility for that. And that has contributed to confusion and concern, reflecting on the level of uncertainty and the need for greater clarity. I believe that deferring a decision is the right thing to do. It is important that we take the time to ensure that everyone has the accurate information. So I'll delay, but I'll call for a seconder, if there's a seconder to my motion. No?
Through the chair.
Are you happy to second, Councillor Greenside? Thank you.
Through the chair.
Okay.
I'm sort of just concerned about the process here. We have a recommendation. Surely we actually have a move and second and actually debate and reject that or approve it before we go into any other.
So now everyone can debate.
No, we have to
I've
debate.
moved it.
We have to debate. No, that's not the right process. We have to debate the actual recommendation and move it and second it, and then either we approve it or reject it, and then go on to the other options. That's my understanding of the process.
You can debate now.
Debate now. Those,
Well, point of order, Chair. I have further questions for the staff.
cool.
For the questions
Okay.
for the staff.
I'll allow the questions. I'll put my motion on the table. It has been seconded. The councillors can now answer, ask questions, further questions, or clarification. Or Councillor Lachlan, you were next up. Sorry, Councillor Greenslade.
I just want to comment on them. I've seconded it so people can debate it.
Yes. Yeah, absolutely. Councillor Lachlan.
Sorry, I tried to get my question in. So can I drag Nick back? So I just want to be clear, so Councillor Rankin raised the issue around the impact on land. Sorry about that. Councillor Rankin raised the issue around land, but I think we just need to be clear that we don't have any, we as in the JMA, doesn't have any ability to change that. What is in place is the ability to be involved in annual plans, long-term plans, etc., through those mechanisms, and no direct ability to influence what happens on land in this district. Does that sound correct?
Errol.
I guess in response to that, what I would clarify is essentially what the legislation says, which is the joint management agreement has to include a number of processes related to the Resource Management Act in terms of monitoring and enforcement, plan making in its broadest sense, resource consents, and the consideration of customary activities. All other matters are additional matters.
Councillor Fletcher.
Yeah, Nick, I just wanted to get clarification, if you could. The scenario that Christine Rankin has given, how are those situations dealt with currently?
As far as I'm aware, there wasn't a specific situation that was outlined by Councillor Rankin. But if you've got a particular scenario, then quite happy to talk to that.
Apologies. No, it wasn't this. Yeah, sorry, it was the situation and scenario that you presented, not Christine Rankin. Sorry, Christine. The situation that you presented, what is our current process in dealing with that situation currently?
So if council's going to dispose of treated wastewater to land, then council requires a consent from the regional council. And normally in the preparation of that consent process, council will talk to parties who are potentially affected by that, who are in the community. And for the sake of clarity, that would almost certainly include the trust board if it resulted in that activity occurring within either the lake, the catchment, or the Waikato River catchment. It would also include hapu and other interested community groups.
Councillor Campbell. Sorry, Councillor Shepherd. Okay.
Through the chair. Oh, sorry. I know it's tricky to follow. Yeah. Just wanted to get some
Sorry, Councillor Williams has got the red light, so you go.
I just want to get some clarity around the actual resource consent applications. The last 12 months there's been, over 350 resource consent applications, and approximately 10 have been forwarded to the Trust Board for the information consideration. That would be correct. Thank you. Perhaps Heather can...
Heather, Resource Consents Manager. Good afternoon, Heather. Sorry.
Kia ora.
Kia ora.
Yes, so the information around that was that our current, in working our current relationship with the Trust Board, for the past year, we get generally around 350 resource consent applications. Out of that, we've identified when they've come in that there may be, it was about 10 applications that, given their location, given what they're about, given matters that were already discussed perhaps in the application where there had been consultation with the Trust Board, that we then send that application to the Trust Board, and basically it's a heads up, this has now been lodged, this may be of interest to you, you're welcome to come back and ask us questions or seek further information. Like I say, some of them, they already had input from the Trust Board, which was appropriate for what the matters were, or it was us through our relationship giving them the heads up so that when they see a property being redeveloped near the lakefront or in some other matter, they're not coming to us and saying, where's this come from? They're already, as a good neighbour, so to speak, already aware of that.
Councillor Shepherd.
I was just reflecting on the questions asked by my colleagues, and it's, I guess, an example in my mind that I'm wondering about. If there is a resource consent application that affects even just connection to stormwater or wastewater, could that be argued as affecting the water?
Sorry, asking if there's a new connection.
Let's say, for argument's sake, that there's a family wanting to build a house that's larger than is allowed under the district plan and therefore has to apply for a resource consent.
Mm-hmm.
Under the current agreement, could that be considered to be affecting the water in the sense that the Trust Board might like to have some input?
So it's not the intent of the way that's been written. And
but is it possible under the current draft of the agreement?
I don't believe so. I think there's matters that are I can say, normal business connecting to wastewater, adding onto that. If there's a specific rule in the district plan that talks about extending infrastructure,
Yeah.
and in that we may consider where that is or what it's about. So
yes.
But that's different to saying that's a different consideration to there's a piece of land, it's got a new connection for a new build. This is where you're specifically extending public infrastructure. So as part of a subdivision, you're extending some of those services. That may be one of the considerations that comes into play, along with a number of other things that we're looking at anyway. And so that may be, yes, an identified aspect that we say, depending on where it is and what it's about.
Okay. Look, I'm just acknowledging it's a really complicated document. It's gone beyond what is required under the Rivers Act. It's been extended to Taupō waters. And I did actually have a note here because, and thank you, Sue, for the very comprehensive report. I'm glad I was able to go back on the timeline because I wasn't privy to a lot of that information. But I was on council when the September 2024 resolutions were passed. So I'm fully aware that Taupō waters was agreed to. I'm fully aware that the extension matters were agreed to within this scope. I am struggling to understand how the extension to Taupō Moana happened without a resolution from council to expand that scope. Can you explain that one, please?
I can, yes. That is a recommendation from the Joint Committee that came about in discussion with the Joint Committee, and I can talk to why that came about if you...
Well, you did explain in your address to us initially. I guess what I'm getting at, though, is that I'm acknowledging that the community was not brought along for the journey on this one, and I'm identifying that actually the councillors not on the steering group weren't brought along for that journey either. So we were effectively blindsided by the extension to that recommendation and not expecting it, and bearing in mind we had 4 workshops, but 2 of those workshops we didn't have a document. The 3rd workshop we had one that was outdated with changes in train, so we've only had the opportunity to really look at the document and not even understand that extension because it didn't come from us. The scope was not approved by us, so you can understand how there might be some confusion as to how that happened.
I can understand that, but you, the council, set up the Joint Committee to do exactly that work. This is a recommendation that's come from them. We have talked about the extension to Taupō Moana in all of those workshops that we've had. We've had 5 workshops with the council, and in every single one of them we have explained that. I appreciate that you haven't had the detailed wording of the JMA until relatively recently, and that was because it was still under negotiation. But
yes,
I do
negotiation scope that was set by resolution of council in September, and this is outside of that. Anyway, I accept your explanation of that. My next question is, who is ultimately held accountable for the processes and protocols managed under the JMA? I'm thinking, for example, if there's a legal challenge, judicial review in the Environment Court, who will defend that challenge? Will it be the Trust Board and TDC, or is this the delegation of TDC?
Carol.
Just to be very clear, the Joint Management Agreement talks about council processes, and it's the way that the Trust Board can be involved in those processes. So because they're your processes, council processes, if there's a judicial review of one of those, or an appeal to the Environment Court through an RMA process, then that's your process and your decision to defend.
Mike. Sorry if I'm stealing. You continue as well.
Where you going now?
I'm
Oh, is it my turn? Sorry, you finished, Rachel.
Still getting used to the new intercom system. Councillor Shepherd.
The reason for my line of questioning is obviously under the resource consents, the Tūwharetua Māori Trust Board does provide input into the conditions of that consent. If there's a disagreement between TDC and the Tūwharetua Māori Trust Board, what is the process from there? I'm thinking because we've got consultant planners and applicants who need to understand our process, and it isn't entirely clear where to from there.
So the decision on a resource consent is a council decision, and council officers or elected members, depending on who has the delegation, has to be comfortable issuing that decision, including any conditions that may be part of that.
Don't turn it off.
I guess the comment that I've heard in the public and from consultant planners is just that they would like some further clarity on that, just given they need to work under this agreement as well, and they'd like to understand where the delegation lies, and it's not entirely clear to them under this agreement. So thank you for answering those questions.
Okay, Councillor Campbell.
Thank you, Your Worship. I just have 4 questions, and leads on from that line of questioning too, actually. 2 of them related. Why is there no provision for full independent legal review of this JMA before we bind future councils to it, possibly indefinitely and outside Standard Local Government Act protections?
It has been legally reviewed.
Yeah, I don't think we've been presented with that. An independent legal, not a legal review by a council lawyer, but an independent legal review. That's what I'm talking about.
So the paper does refer to us having legal support during the negotiation process, and that lawyer has checked it and made it sure that it's aligned with legislation and provided a legal review.
I don't think we. Is that an independent law? Have we been given that to look at?
So they've worked with, obviously, this is something that has been negotiated by your joint committee, and so that joint committee's been involved in that process. Yes, it has had a legal review, Duncan.
I'm happy to share it if the councillors want to see it.
Follow up, Councillor Campbell. You got another one? Question? Oh, there's someone else.
John's next.
Oh, thank you, Your Worship.
Okay, Councillor Williamson.
Thank you, Your Worship. Yeah, thank you. I was one of the alternate members of the council on that committee, Joint Management Committee, and had a fair bit to do with the being socialised, a fair bit with the Taupō Trust Board staff and council staff, and there was a lot of hard questions asked, through the process, getting sort of a lot of agreement across the divisions within council, because that, to be quite comfortable, and to also through the trust board staff as well to be comfortable. So the process has been followed, and I think obviously with regard to Councillor Shepherd's point about the actual recommendation back in September 24 that was related to Taupo Waters, was a democratic decision, but I must just acknowledge the 3 councillors immediately to my left, and former Councillor Park, four of the 5 they'll have the utmost respect for, and respect to what decisions made today. That was democracy and process, and I think with the actual extending it to Taupo Moana Waters and tributaries obviously makes perfect sense to me, but I think that's obviously, that decision here will be tested today around the table with the members, whether they accept that or not.
Councillor Rankin.
Sorry, if I could just interrupt proceedings, Your Worship. So we're clear on process. The staff are here to answer questions. No disrespect to everyone, but if we could confine ourselves to that, the debate should be amongst us. Once the questions and all clarity has been sought, so we don't entangle staff in a debate and a decision which is ours to make. So no disrespect, but I think if we could confine ourselves to asking questions of clarity, release the staff, and then we can have at it in terms of a debate, yeah?
Okay, I think, the questions
through
have
the
been
chair,
sort of clarification.
I do have some questions.
Oh, Councillor Rankin was
I'll do
next.
it.
Mine's just clarification from Heather. The description she gave me of what currently happens, will there be, if this were passed, would there be any change in that process whatsoever? And would there be more impact from any input from the Trust Board?
So in terms of what's been written into the JMA is essentially a process that has been in operation between ourselves and the Trust Board for some time in terms of communication on resource consents. And it goes towards meeting other obligations in the district plan that are already there and under legislation in terms of understanding cultural values and matters. And what we've tried to do here is try to put down in writing, for clarification really, a bit more certainty about the types of matters that tend to be of most concern to the Trust Board or interest to the Trust Board in fulfilling their responsibilities, in order to sort of filter through 350 consents down to just the ones that are most of interest and impacting to them. That also is to try and give clarity then to applicants so they know these are the types of things that there's a clear expectation that there would be consultation and involvement on with the Trust Board. So will things change? My expectation of the way we currently work and going forward is no, except that as the relationship grows, as our understanding grows, as our appreciation of the values, because we're talking about these consents, yes, there may be other things that through that education and understanding that we may change and improve, and that's to be expected over time as the relationship improves and perhaps some of our other parts of the district do get developed. So yes, there may be changes, and that's to be expected of anything.
Councillor Campbell.
So on 16th of July, Central Government issued a national freeze on RMA plan changes due to legal uncertainty. Given that this JMA embeds co-management functions across planning, consenting and enforcement under the RMA, can staff please explain, firstly, I'll wrap this up all in sort of two questions in one, but why the 23rd of July staff paper on public engagement makes no mention of that policy directive, and why is the JMA being recommended to adopt now when delay could avoid having to amend a freshly ratified legal agreement? And I lead on to the next question, and you say that this is a question I've been asking the past week actually, but I haven't had a response, but has Council obtained any independent legal advice on exactly this matter, whether adopting the JMA now will create future legal risk or expose the agreement to procedural challenges?
Councillor Taylor, you got a query?
Oh, aren't they answering first? Sorry. Oh, I was next.
Yep. So 2 questions in there. I'll take the second one because I can remember that. I think Sue's already answered that, and the Chief Executive's answered that around the legal advice that's been provided during the drafting process. In terms of the first question, I believe you are referring to the fact that the government has signalled that they would like councils to stop preparing plan change processes in relation to their district plans and regional plans. We've certainly thought about that, but as Sue noted in her introductory comments, we know that we have to adopt a joint management agreement because we have a separate piece of legislation which requires that. We know it has to cover some mandatory matters. We know that regardless of the RMA reform, that joint management agreement will continue to exist. But we also know that we're probably going to have to amend parts of it once the RMA reform is put in place.
Councillor Lachlan.
Oh, well, through the chair, just to respond briefly. I mean,
no, sorry, Councillor Campbell. Can we let some other councillors have a go? Councillor Campbell, could you press the button off? Councillor Lachlan next, please, and then we'll come back to you.
Your Worship, I mean, I asked the question and I've had an answer. I think
2 questions and they were answered. They were answered. Okay, Councillor Lachlan next, please.
Kia ora. Mine's more of a statement. So for those of you who don't know, we had a wastewater break near the Waikato River, near the Control Gate Bridge last night. Fortunately, we think that there wasn't a major any spillage into the river, but that was not Council's immediate. They originally thought that had occurred. So I just want to remind ourselves too, while we're here, this is about activities that can impact on legally the Waikato River from Hoka Falls, but if the extensions take place, being more considerate about what happens in terms of Lake Taupō and its tributaries. And we have a number of activities that Council's involved with, whether it's rubbish dumps, landfills on the bottom of Mount Tauhara, wastewater in the northern area of Taupō, but also in Turangi. So those are all live issues now, and it's I believe that the JMA will enhance the work that needs to be done through its formality. It's been quite clear through all the answers from our staff. Most of the things that will happen already occur right now. This will just bring some formality to those processes, and hopefully help with some communications.
Thank you, Councillor Lachlan. Councillor Taylor.
So just to go back, and at the risk of answering on behalf of staff, it is not the RMA consents and plans that have been changed. Minister Bishop talked about district planning, and his instruction was quite clear, and the two are quite distinct. And it's actually really important in this environment we don't mix the two, because that's how we get into the confusion that is out in the community now. You take a little bit of this and you take a little bit of that, and you come to the wrong conclusion. So it's really important we stick to facts and we're accurate in what we say. And your second question has been asked and answered twice now.
Councillor Campbell.
Yeah, through the chair, I think it would help if information is put out in plain English that people can understand, and there wouldn't be misunderstanding, actually. That would go a long way to help. And regarding that independent legal advice, I asked our CEO in the last week or so, was it around, can we get it? And I never had a positive indication that there was something already sitting around. But I'll move on to the next question. Co-governance framing. The staff paper seems to claim that concerns about co-governance are not relevant, but as I see it, when unelected parties do help shape public land decisions, policy frameworks and enforcement mechanisms, I ask you, how was that distinction reached? And even if technically accurate, do staff accept that public perception is also relevant to democratic legitimacy?
Is it fair to let the staff answer that? Nick, have you got a short answer for that, please? Well, the short answer help. It's irrelevant. I think the staff have had enough questions chucked at them, but Nick, just a quick reply, please.
The short answer is, in many of our processes, we involve people who are not elected officials, elected members, or even council officials. When we're developing plans and policies for the future or talking about infrastructure development, we talk to the community. And that doesn't mean it's co-governance, simply because we're talking to the community.
Thank you, Nick. All right.
Through the chair, I just have one last question.
Oh, really?
Please.
Last one.
Yeah, interesting response. But my last question here, the inclusion of Lake Taupō and clauses 118 to 11155 or further matters were optional expansions, not legally required under the Upper Waikato River Act, given that these voluntarily extend the JMA's scope. I need to ask, why were they not deemed significant enough under the Council's own engagement policy and recommended to be put out to public consultation? And I think the 500 pages of material dumped to us yesterday for us to read on informal submissions amply demonstrates that there is significant public interest.
So you'll see in your paper you have an assessment against your significance and engagement policy. That policy sets out a number of criteria, and the assessment has looked at those criteria. those criteria don't include, are there a lot of people who are interested or have contacted council? The criteria that you're probably thinking about talks about, are many people or organisations or businesses affected, and that's why the assessment has done a look at the provisions of the JMA and has said, what impacts will these have on people in their day-to-day lives, particularly in the context of the functions that council delivers?
Yeah,
So-
I just throw in a comment that I think if no one, if that number of people weren't more than insignificantly affected, they wouldn't be bothering to call us.
Okay. All right. Yeah. Okay, we've heard it. We've heard it. He did say, Councillor Campbell did say one last question.
Well, that
Okay,
was it.
so I'll go back to my original motion that was
Can I ask a
moved and
question?
seconded. Councillor
Can I ask a
Greenslade,
question? Yes.
as a seconder of that motion.
I just want to ask Saf a question.
Okay,
Yes, I haven't spoken yet.
One last one, sorry. Okay.
Staff, you may not be able to answer this question, but I'll give it a go. The Upper Waikato River Act had its first reading in Parliament in May 2010. It was sent to a select committee on the 20th of July in 2010, and the whole House voted on it on the 13th of October 2010. It received royal assent on the 26th of October 2010. At that point, the Raukawa and Te Arawa people were, of course, involved in the whole process. They signed in 2013, and Te Arawa has signed in 2017. WRC, Waikato Regional Council, entered into a JMA in 2016. I believe that, I know that Taupō District Council gave submissions to the Select Committee. Interestingly, the submissions that they gave were sort of the ones that we've talked about the RMA and about costs. That was their submission at the time. And plenty of people who were affected by the Act also gave submissions. I am thinking to myself that I believe the consultation process at this point is right for our community, and the reason I say that is because the original Act went through a submission process and it did go to Select Committee and people were able to make their submissions, and the additional matters have not gone through that process. So there's two questions there. It could have gone back to the House and we could have had a separate Act for the additional matters, or we could listen to the Court of Public Opinion, which has been deafening, and say perhaps consultation is right. I'm very interested in Topia and Zane's comments. They both said the same thing. It's divisive, it's upsetting, it's not who we are, and I would like to think that perhaps we sort of make that brave decision and do something slightly different to what we were intending to do, based on the fact that people did have the right to make submissions in the first Act. I don't know if there's a question in there, Sue, but that's sort of how I see it, yes.
I think there is, and you're right, you recognise that the legislation came about as a settlement between the Crown and the River Iwi. There was a recognition that the Crown alone had not done a very good job of managing the Waikato River. The Waikato River was a mess. So that it was time for the Waikato River Iwi and the Crown to work together to correct that, to improve the Waikato River for our future generations. There was a recognition that legislation like the Resource Management Act gave the power to approve resource consents, to set up district plans, rules in district plans, and that there was a requirement that the River Iwi were also involved in that process, because how could we improve the water quality and the association with the Waikato River unless we work together? The intent of that legislation is really, really clear about what it sets out to do. There is also the requirement in there, as you rightly point out, to include additional matters. The Crown and the River Iwi felt quite happy for those additional matters not to be identified, because they will be different in every single circumstance. It is up to the river iwi and the council to work together to agree on what those additional matters should be to achieve the purpose that the settlement legislation set out, which was to improve the relationship with the Waikato River and the Waikato River generally for future generations. That's why they felt quite confident to leave the additional matters as open for those two parties to agree, because those additional matters have to result in achieving the purpose of that piece of legislation.
So in the JMA, going forward, if it's approved now, do Tūwhare Taumārea Trust Board and Taupō District Council consult also with Raukawa and Te Aroha at the same time under the Act?
Sorry, I'm a little bit confused about the question. Say it again.
Because we're operating under one Act, does the consultation include them as well?
I'm not talking about consultation. I'm essentially saying that the settlement legislation enables the two parties to come together to agree on what those additional matters would be. The settlement legislation quite clearly at the time outlined that you should not use the special consultative procedure for this.
But it's not two parties. That's the point that I'm making. Raukawa and Te Aroha are
they
included
are separate legal agreements.
They're separate.
They're completely separate legal agreements. They're under the same piece of legislation, but they're separate.
Cool. Thank you, Sue. Thank you. You can stand down there. Thank you very much. Okay, right, moving on. I've put a suggested recommendation on the table that we defer this because of obviously still ongoing confusion around the table, and I take the words of a gentleman I very kindly respect, Mr. Taupō Ramaka. If we cannot decide today, Kaiti Pai, we move forward and get more information and send more information out and leave it for the incoming council. So that's the resolution that I've suggested on the table. It's been seconded by, I believe, Councillor Greenslade. Thank you. Does anyone want to speak against that? Councillor Williamson?
Yes, Your Worship. Not per se against any of the options, and I respect the comments made by Taupō Ramaka and John Fennell. And sort of obviously there's caused a lot of distress amongst the community, but and I just want to clarify, obviously I'm not quite a support of carrying over when you to another triennium, and John mentions that that the other one, the next triennium should be dealing with, and they haven't been, and they will need to be socialised and go through back to square one. So, and I also don't believe that just because I'm not re-standing for election, I shouldn't be compromised in making my stand here, because I believe that the position taken by the sitting councillors that have aspirations to be re-elected, that is any political capital or have made no other decisions, is honesty with integrity. And I should be held in the same respect, for any decision I make. So in that case, I don't support the option 4 going forward. And it twins a little bit with of my 12 years I've always been a great advocate of consultation in the community, but I don't see anything in there and being socialised with that with Tū Wharetai and with the Joint Management Committee. There's anything that's going to trigger alarm, and we just need to move forward.
Thank you, Councillor Williamson. Anyone else like to speak against that particular?
Well,
you want to speak against the resolution?
Speaking to it slash against it at the same time, if you like. In my mind, option 4, deferral until after elections does seem to offer the wisest step, because this council is only weeks away from dissolution. And binding the next council to permanent unalterable terms now would be constitutionally feckless. But let's be clear here, please. Deferring it without direction, I don't think is integrity. I think it's an act of procrastination and political convenience, actually. But if this council votes to delay, and if it does not require if it votes to delay, but in but it still does not require public consultation or publicly viewable independent legal review. I'll make that distinction. Then we're not solving the problem, we're only refusing to clean it up and simply handing the live grenade to someone else. Deferral without these conditions of compulsory public consultation and publicly viewable independent legal review allows the same flawed agreement to return after elections, unconsulted, unchallenged and unexamined and publicly viewable in those terms, and an incoming council can still decide to sign it off on day one. So to that point, I say if we truly believe in democracy, then we will be committing now to public consultation and legal clarity. Otherwise, as I said before, I think it's just an act of political convenience, cowardice even. And I did submit my amended notice of motion for this option 4. Seeking an amendment. I don't know if it's the right time to do that right now or...
One moment, please. Is there any support for Councillor Campbell's suggestion?
Well, I'm not sure if they've all seen it.
You've seen your amendment to the resolution that
yeah,
you...
I think they can bring it up on the screen if they...
Yeah. Councillor Lachlan, did you want to have a go? Oh, sorry. Councillor Rankin?
I just want to... Sandra.
Oh, me. Well, I'll say what I've got to say. I would just, through the chair, encourage Councillor Campbell to have faith in the democratic process.
Councillor Rankin and then Councillor Lachlan. Thank you.
I've got a few things to say. I half agree with that, but consultation has to be added to it for me. The community has screamed at us, and I think we've handled this very, very badly. Even today, with the comments being made about misinformation, etc. You know, we're politicians, whether we like it or not, and people are entitled to a view that's different than half the other people that sit around the table. And if they want to bring that out and they want it discussed and debated, we've just never done it before. We need to get real. This is the reality of something that feels as controversial as this, and it probably shouldn't be, but I believe that it has been minimised, and in thinking about it a lot, I think that it reflects an ideology that we've become absolutely immersed in that blocks out talking about potential adverse effects, and because we haven't talked about them, everybody is afraid, and that has created the horrible thing that's happening out there at the moment. And we've done it to ourselves, and I think we need to take a hard look at ourselves. We're allowed to have different opinions. We're allowed to express them any way we like. We can go to anybody we like in the whole of New Zealand and debate it. That's politics, and we need to stop getting at each other for it. But one thing that I do want to question, and Councillor Taylor, it was something you said, and I know you've been to the recent conference and the Minister spoke there, but I rang Minister Bishop's office last week to ask were there going to be any implications for councils with the RMA, and they assured me there were. Legislation's going into the House by the end of the year and will be implemented next year, and it does indeed affect many of these things, which will need to be reversed, were their words, if we move against their current advice. So obviously they're telling us different things at different times in different places, which is very confusing. But I go back to something I read again this morning that said there is no right to terminate this agreement, and it is written in there very, very clearly. So I'm sorry, our community has screamed at us that they want us to consult with them. The original JMA, I'd be happy if the tidy up of that, which is what I naively thought it was, can be signed today. I totally and absolutely support that. But the rest of it, the community deserves more than we're offering. And yes, I want it deferred, but I also want public consultation. It doesn't have to start in the interim. People have a right to say what they think, and if we want to grow our relationship together of both parties, and I hate calling them that, then we need to get our act together and let people say what they want to say and debate and discuss it.
Councillor Lachlan. Oh, sorry. Councillor Taylor, just a clarification on Mr Bishop's comments.
Well, couple of things. Again, they are two separate issues. Yes, the RMA is going to be repealed and replaced, but that is not what he said last week in terms of district plans. They are two separate things. Yes, they both apply, but you're mixing the two together in one context, and they need to be really clear about that. The other thing I would say is absolutely everyone is entitled to their own opinion, and I respect that, but opinions do not suddenly morph into facts. Facts are what they are. If I have an opinion on something, the fact that I repeat my opinion multiple times doesn't suddenly morph into a fact.
Councillor Lachlan.
Oh, through the chair. Oh, you think? Oh, I just want to
Back to Councillor Williams.
Not challenging Councillor Rankin, but obviously the context of the agreement, the draft agreement, review and amendment of agreement, with an issue resolution, termination agreement. Yes, there is no right to terminate the mandatory matters, but there is capacity to terminate the additional matters. And I must also want to reinforce that Council is the final decision maker over this agreement. Hopefully with resolution, with good resolution and agreement with Tū Whakatau Maori Trust Board. Council are the final decision makers, whether it's this term or next term. And the other thing is I want to mention, obviously, and Duncan perhaps worded it perfectly, and unfortunately politically, an agreement like this transcends political trienniums and even change of management within both parties, Council and Trust Board. It's the safest space to be in future for us, for future generations.
Kia ora. My comment is, and it's already been explained earlier, that the consultation in terms of this legislation happened through the select committee process through government. So the conversation that needed to take place happened back then, and the government of the time made it quite clear that the expectation is there would be no further consultation because it was done at that time. So I'm quite clear on that. In terms of speaking against the resolution, we've got a quite clear recommendation from our subcommittee and a recommendation from our staff that this should proceed and that there's a legislative requirement on us to complete a JMA. So for those reasons, I will be voting against the proposed resolution.
Thank you, Councillor Lachlan. Any other commentary? I'll make it clear with my original resolution, I'm not against the JMA. I'm just wanting to defer it to close to incoming new council, there's just too much. And I agree with Councillor Rankin, there's too much disinformation out there, not information. We need to make it clear to our people, step by step, through the potential JMA. So certainly not against it. It's all about protecting the lake and all that sort of thing. And if not, I'll put my resolution. Still people? Okay. Councillor Fletcher.
Yeah, I hear everyone, and thank you all for sharing your whakaaro in and around the resolution that's been put forward by Your Worship the Mayor. I think we just need to be careful because our role as councillors is, I think it felt like the debate's got into almost like a case-by-case kind of scenario. And I think when we get into case-by-case or we get too far into the detail, it can unwillingly distort our ability to make actually a strategic decision. And when I look at the joint management agreement, it ticks a lot of boxes. Probably ticks more boxes as to why it should be adopted at today's meeting than why it shouldn't. I look at the reasons as to why it should be ticked off today. It strengthens our relationship for sure. It improves how we work together, absolutely. Time efficiencies through early engagement, shared planning, clear processes that avoid both duplication and clear processes that avoid delay. It upholds the values. That's why I'm really struggling with the values part. It upholds the values that actually guide the Taupō District Council. It even guides the wider local government sector. Community well-being, protecting our environment, making decisions that are future-focused, and honouring our obligations under Te Tiriti o Waitangi. I get disappointed that a document that's actually grounded in cooperation and care has actually been misrepresented in public debate. You know, it's turned from actually what is, if you stop and take a step back, right? It was actually created as a tool of unity, and somehow it's now used as a source of mistrust. It perplexes me. And that's not what this agreement is. We all know, when it comes to the people that have involved in its creation, yeah, that it's a source at its core. It's not about control. It's about cooperation. And yes, I totally agree. We might not all agree, and that's okay. Okay? But we can and we must do better. We owe it to our community to deal in facts and not fear. And we owe it to our mokopuna who deserve solutions, not division. So that's why I will be actually voting against the proposal, and I would recommend that we go with the initial option that was presented by the Joint Committee, and option 1, and that it's adopted at today's meeting. Kia ora tātou.
Through the chair.
Councillor Shepherd.
Beautiful kōrero, tough act to follow, very eloquent with your words. I would just like to point out that I'm not against the JMA. I'm not. I think it is sensible to have a relationship agreement in place, outlining processes and procedures that is fit for purpose. I 100% agree. My career outside of council was very heavy in contract law, and I'm just trying to ensure that we have a legally robust document that all affected parties understand and know how to work to. I think there needs to be clear delegation, clear dispute resolution. The intent is really clear in this document, well, when it's discussed and when questions are answered, we need the document to reflect that intent in the reverse way as well. Nobody gets married expecting to divorce, but we have to accept that there will be times when we disagree. I think there will be far more public trust if there is a process that is clear to follow. I take note of the concern around timeframes, and in all honesty, back in September, I was very concerned about these timeframes. I recognised it was going to be a very complex document, and the 30th of June deadline to me wasn't achievable. Turns out I was right. And I was also concerned about the elections coming up, because in all honesty, this decision feels like it's being made politically instead of in the best interests of the district. I'm concerned that the discussion I would like to have to get a fully robust document was not able to happen. And I think we owe it to make sure that this document is exactly what we need it to be. So I'll be voting in favour of the recommendation. I don't think a good decision will be made today, but being so close to the election, I do feel there's been some, dare I say it, electioneering, and it's not a good environment to make a decision. So I'm in favour of delaying it until the next council is sworn in. But I would also like to see that this is advanced as quickly as possible and that the right discussions are scheduled to happen.
Thank you, Councillor Shepherd. Councillor Lachlan.
Just a question in terms of clarification. So, do you have to accept the amendment, or is it, because we had a resolution and then the suggestions of amendment? I'm not clear about. Am I doing the yellow, or am I doing the yellow and the blue? But I just want to be clear about the legal position. Do you have to, as the mover of that resolution, accept those amendments? And second, do you actually accept them, or are you happy just to stick with what you have?
I'm happy to stick with the original resolution. It's been moved and seconded that we defer this. Councillor Campbell has made a suggestion, but have you moved an amendment? Have you moved that amendment?
Yeah, I'm moving the amendment.
So regarding Council, consultation, is it up there?
In the blue.
In the blue. Yeah, I'll call for a seconder on that amended resolution, otherwise the substantive...
I better give them a chance to read it, I think they're just looking at it, yeah.
We need some more bifocals. Yeah.
Speak now, Karen.
Do I have a seconder for Councillor Campbell's amended resolution? Okay, so I'll go back to my original resolution. There appears to be no seconder for that. So I'm ready to prepare the... Councillor Taylor? No, the amendment hasn't been seconded. The substantive resolution's still on the table. Sorry, Councillor Rankin.
I'm not used to doing this, so you have to advise me. I support your amendment, except I want consultation, future consultation added to it. Doesn't have to be immediate, but future consultation added to it.
Yeah.
What do I do?
So is it not the words of Councillor Campbell?
Dunk's, no.
Yeah.
Just yours with a full consultation added to it.
Cool, thank you. So that's the third amendment. Third.
Yes, with full public consultation. That means everybody.
Yeah. That's another amendment to the amendment.
Sorry, I'm sorry.
Okay, so is there any support for Councillor Rankin's amendment?
Okay.
You've already seconded the first one. Okay. Okay. Councillor Shepherd?
Can I speak to that then?
Yeah.
If you're going to put that in, I hear what you're saying, and I hear what Christine's saying, but I'll be very careful in the words that I choose. We need to bring the community with us. I accept that. We have a robust document before us, and I'm reflecting on what Councillor Fletcher said. This is about relationship, this is about partnering, this is about working together. We've had a legal review, albeit Councillor Campbell hasn't, or we haven't been privy to it. I'm comfortable that it has been scrutinised independently of Council, and it is a robust document. And we've had a legal review on the consultation, which we have had access to, and it is intelligent, and we've had an opportunity to read it. And that is quite clear on 2 points. Firstly, the mandatory matters are not open for consultation. That's not a decision that I make on my own, that's just what the law says. It's pretty simple, and we have no choice. Which leaves us with the extension matters. That is an arguable point, reading the legal opinion, and the arguable point rests on our significance and engagement policy. And we've had a robust assessment done there. Now we can choose to accept or reject that, but it is a robust assessment, and it says in terms of our own policy, in terms of the matters that we are to take into consideration, that this is not one that we would go out for consultation. Not my decision, not my opinion necessarily, but that's what the documents have said. Sitting alongside that, we have, as has been said by a number of people here, and there's probably a number of them in the audience with us today, significant public concern and input by way of emails and text messages and so on and so on. And we've had a whole lot of those given to us in the last 48 hours. But if you read through them, they're actually reasonably evenly split. They're not all against us. There is a significant body saying, just do this. So if you're going to look at that, which, according to what Nick told us earlier on, is not one of the matters we can consider in terms of our significance and engagement policy, then you come down to, well, we're going to bow to pressure outside of what the law says, outside of our agreed policy says, But that pressure is split. It's two ways. So that brings us back to what was an appropriate thing to do. I hear what you're saying around consultation, and reading the room, it would appear that looking like this is going to be left on the table. My personal view is that this is a robust document. There are some things that need changing. We could change that. But had the motion been to put it through, I would have voted in favour of agreeing to it today. That's clearly, as it appears, not going to happen. But there is another path in this if we agree to put it on the table, and that is we engage in a public, or consultation is one word, but engagement process, so that the disinformation, and I've been challenged on that a couple of times today, but there's no other way to put it. If you say something is true and it's patently not, there's no other way to describe it. If you call something what it isn't, I'm sorry, but I call it as I see it. And that gives us an opportunity to take the community with us. Now, at the last open workshop we had, I made the offer to everybody that's sitting where everyone is here that I would meet with and discuss with anybody and everybody that wanted to do this. Numerous people took me up on that. What was abundantly clear is that most of those people, not all of them, but most, had not read the agreement. They had simply read the information that had been put out by way of email and regurgitated that. And when I went through clause by clause with them, much to their surprise, they realised they had been fed a line that simply wasn't true. Some of those I spoke to had some really good input and made some suggestions which actually was quite valuable. So if we're going to engage with the community, and if we go in our standard consultation process, which, let me be really clear, I'm not opposed to consultation. I think we need to bring the community with us. However, if we go, are you in favour of this or are you not in favour of this, based on the public square and the poisoning of the information that's out there now, you're not going to get an accurate feed. We need to get the accurate information out there so people can understand clearly what we're talking about. And one final thing, and I digress, it's really interesting that this, which relative to the next item, which I'll lean on what Topia said earlier on, the next item on our agenda is going to affect everybody in this room significantly, forever. And that's our water services delivery plan. And I'll be interested to see how many people stay for that. Just saying.
Thank you, Deputy Mayor. Thank you. All right.
Through the
Okay.
chair. Yep. To the
Councillor Campbell.
Yeah, just following on from that, I mean, it's following on from Councillor Taylor's comments about misunderstandings, misinformations. I mean, not everyone here is a lawyer, and I've heard a lot of talk about this independent legal review, which is news to me now, despite my asking before. I would, and which was the second part of my amendment. I think the public deserves to be able to read that independent legal review, and I think that should be part of the public consultation for them to be able to see an actual independent legal opinion on this.
Councillor Greenslade.
No.
Oh, sorry, Sandra.
Thank you. Thank you, Deputy Mayor. I do think you've argued in favour of a limited consultation process for exactly those very reasons. People don't even read the whole article on something and they'll make a comment underneath with only having read a headline, and I think you're quite right in what you're saying. I'm wondering if we should add, Councillor Rankin, consultation on the additional matters, because everybody's right that we can't and we shouldn't, and it's not correct to go to consultation on mandatory matters. So I just suggest that we include that into it. I also want to comment too on page 72 of the agenda. I actually disagree with the criteria for the significance of consultation. When I go through there, and I'm not going to go through it in detail, but I have to say I don't think it's correct. I don't think they've got it right, and I would certainly encourage a consultation process on additional matters in the community.
Councillor Shepherd.
Again, I'm not against consultation either. I'm just very aware that there might be a misunderstanding on what we're consulting on. And I'm also conscious of the fact that we're leaning towards a recommendation that doesn't compel the future council to anything. And if we include that in our resolution, we are in fact telling the future council they must consult, and I'm not sure if that's our place. I wonder if it's a recommendation that they consult on the extension matters. That's the basis for which we're delaying this decision, and I think we should be consistent with it. I am in full support of informative community consultation on the extended matters, but we have to be very clear what the community does have a say on and what they don't. And there is a significant cost to going out for consultation as well. That shouldn't be underestimated. So we need to weigh that up and ensure that the community are very clear on what we're able to consult on and be very informed about what that actually means.
Councillor Fletcher.
Yeah, and fantastic. Thank you, Rachel, for saying that, because, again, the law is quite clear where these water bodies are concerned that we are expected and required to work together. But it's also important to be clear about what hasn't changed. So even with the inclusion of these additional matters, the capacity building, the infrastructure planning, the economic development, Taupō District Council still retains full decision-making authority on additional matters. Final decisions on bylaws, final decisions on infrastructure plans, final decision on financial strategy, final decision on investments, they remain the responsibility of elected council members. And so, again, we go out to public consultation, we make it clear on the elements that they can't obviously consult on, or we can't talk to the community about, because we're required to do it under law. And then the additional matters, it's really important that we identify what's changed for council in terms of decision making. And those are clear indications as a part of the joint management agreement of what will not change as a part of the additional matters. So I just wanted to make that clear.
Okay, Councillor Rankin. Oh, sorry.
So,
sorry.
Once more, then I'll call it quits. As you've got the amendment up there now, that would bind the new council to our standard consultation process, which I'm not convinced is actually going to get the information we want from people in the community. Many people have expressed concerns for, against, indifferent. I believe a better way of doing it, if we're going to go down this path, would be to ask for people's opinions and input on specific things that they've got concerns with, which is what I've done, and I've been given that kind of feedback, and it's helpful and it's beneficial. Otherwise, you end up with our standard or classic consultation process. It's digital. Do you like it? Yes or no? Well, that is unhelpful in terms of understanding what we're trying to do here, and I think it would be more appropriate to listen more widely to the community and hear what their specific concerns are. Not just the fact that I copied and pasted an email and I don't like it. So why didn't you like it? Tell me specifically what your issues are if we're going to go down this track. So I think the way it's drafted there is going to tie us into a process that isn't going to advance the matter for us.
Thank you, Councillor Taylor. Councillor Rankin.
I agree to additional matters being added, that we just consult on additional matters. People have said there's significant costs if we consult, there's significant costs if we don't consult, and that's about the relationships in our community, and I think that's a cost I'm not willing to be any part of. I also think that asking people specifically what they want is a form of control that I also don't agree with. I think we should have a full consultation process. Our staff are incredibly good at doing it. They're incredibly good at presenting the right information and asking the right questions. I don't see the difference.
Councillor Shepherd.
I'm seeing both sides, and I don't disagree with either. But what I will just say is that I would hate to be put in a position, as if I'm lucky enough to be there next time around, that we go out for consultation and I can't implement what the community is portraying to me. If it's not clear what we are able to consult on and where we are able to navigate, then consultation will not be as effective as it needs to be. I don't want to hear lots of things from the community that I cannot help with. We'll have to make a decision that goes against the majority, and that just looks terrible. So we need to be very clear about what we're consulting on, and it needs to be something that the community actually has the ability to have input in. That's all I'm asking.
Councillor Greenslade.
Thank you, Worship. CEO, could you please explain the consultation process to us so that we're clear on what we're talking about?
Look, normally in debate it's actually for councillors, but I'm happy to answer that question. The paper, you're coming back to what's actually in the paper. So there was two options that were put to you in the paper around consultation. One was to start now and to go out prior to the election, or the other one, which is what I'm hearing from you, which is to wait for the incoming council and that process to start with the incoming council. Now, the paper outlines the likely timeframes and the likely implications around that. The paper, which also outlines that under the Act you cannot use the Special Considered Procedure, which is a special process that's outlined in the Local Government Act, for those people that have been around local government for a little while. What we normally do, just so that everyone understands what that process looks like, is we normally open for a month for feedback. We normally, as a council, go through a community hearings process prior to council deliberating and making a decision. And as staff, we'd be recommending that process, which is your normal process that you follow, just so that everyone understands.
And I have been through a number of these myself recently. Most importantly, of course, was the Matatere Reserve Management Plan, and that I found extremely useful in that we put the information out there, people were able to read it. We had a number of informal workshops that people came along, asked questions, and then we had final deliberations and final hearings where many people in the community came along and actually talked to us about it. I have to say, I found that extremely helpful. I found that the community feedback influenced our final decision making. We started off with one way that we thought we would go, and having listened to the community, we changed our view in line with what the community felt. And I think I sort of flippantly said to Councillor Campbell before, have faith in the democratic process. It is the same situation. Have faith in the democratic process. People on every side need to be involved in listening in the first place. Actually, that's the most important thing, is listening. And then after you've done that listening, then I think personally, again, very useful process for us to go through. So I hear what some of my councillors have said here and binding people into future things, but I came into council, I was bound into things that people before me had made decisions on. I won't be mentioning any dinosaurs.
All right.
Through the chair.
Bit of humour. Councillor Campbell.
Yeah, just before this debate perhaps get closed down with the vote, I just do want to ask a question, and while we're on questions for the CEO, and I'm sorry to sound repetitive, but regarding this independent legal review of the JMA document, if I have not been able to see it, I would like to view it. If I make a Lagoima request, or even if I ask you nicely, will I be able to see it? And the second corollary to that question is, can it be made available to the public to see it for themselves?
Are you happy to answer that now? Or?
Yeah, so again, once you're in debate, it's not normal for you to ask questions of clarification, but for questions of clarification, Councillor Campbell, yes, we can absolutely make that available. It is not provided in a formal letterhead where we'll work to do that so that you can have that, Councillor Campbell. That under normal provisions, legal advice is provided under legal privilege, and so it's not normal that you provide that publicly. We can assure you that it has been through that process, as it outlines in the paper. It states that there has been legal advice provided along through the negotiation process Of course, if council decides that it wishes to provide that publicly, it can do that. But I can assure you, it says that it aligns with the legislative requirements and that that process has been followed.
To make it clear, so I can view it. Yeah, okay.
Cool. All right. I
Yeah,
think,
through the chair,
yeah,
just-
Councillor
There's
Williamson.
no advice being provided for us anyway. We've seen that since it's on our diligent.
You got two of them.
So you've got legal advice and diligent on your significance and you've got
Okay, it's still going, isn't it?
You've got, apologies, you have legal advice and diligent, which for those that are in the audience is the IT system that council has that we provide our documentation to, so you know what we're talking about when we're talking about diligent. So you've got legal advice in there from Simpson Grierson on your significance and engagement policy, because councillors, you've questioned numerous times around staff view on significance and engagements against your policy. What you're asking for is the full independent review of the JMA. Again, we have used a lawyer, just as Te Wharetoa Māori Trust Board has done, to support us through the negotiation process. And so my understanding of what you're asking is the legal review of the JMA and not the significance and engagement process. Is everyone clear on? Yeah, okay, cool. Thank you.
Thank you, CEO. All right, okay, I think there's been enough
You through.
debate. Oh, sorry, Councillor Williamson.
Yeah, thank you. You're through. Just obviously, I won't be supporting this recommendation. At the very minimum, reluctantly, I would perhaps look at option 2. It's just the challenges around, for me, given the disadvantages, may result in invoking dispute resolution provisions under the Waikato River Act. This is obviously would require with mandatory matters. A change in council membership after the election may mean the loss of knowledge and process of negotiations has resulted in the position reflecting the drafted JMA, and no reflection on the capacity or ability of incumbents or anybody new to the table are capable of not making a informed decision. So on that basis, I'll be voting against the recommendation.
Thank you, Councillor Williamson. Okay, well, I originally put the motion on the table. Debate is finished, correct? Sorry. All right, so there's been an amendment coming from Councillor Rankin that just, do you want to check that wording, is that correct? Yes. Yep. All good? Okay, so I'll move my resolution first. No? No? Oh, okay, sorry. That needs to be voted on first. For understanding order 7.4. Councillor Rankin, you've moved it. Did you have a seconder? Seconded by Councillor Greenside. Could I ask all those in favour, please say aye. Could you put your hands up, please? 4. Those against?
I'm against.
5. Oh.
And Kylie and Yvonne, we just need to check.
Kylie and Yvonne. Okay, so that motion is lost. So I'll go back to the original substantive notion that the council defers the consideration of the draft joint management agreement and directs the chief executive to refer the matter to the incoming council as soon as practical following the local government elections, and I've outlined my reasons why. So could I have a did I get a seconder for that? Yeah, seconded, Councillor Greenslade. So it's been moved myself, seconded by Councillor Greenslade. All those in favour, please say aye.
Aye.
Aye. Cameron. Is aye from Kylie? Hi, Kylie.
Can we just clarify
Yes.
who's online?
So this is
Can we-
the council defers the consideration of a joint management agreement and directs the chief executive to refer the matter to the incoming council as soon as reasonably practicable following the local government elections.
Yeah. So hands up again, please. So 1, 2, 3, 4, 5. So the motion, and Kylie, correct?
And Yvonne?
And Yvonne?
I'm against. Against.
Sheila, yes.
She's against, okay. Yes, sure. So just get this numbers right. Sorry. The numbers up again. We've got 1, 2, 3, 4, 5. What was Kylie?
Yes.
6?
Kylie's a hand up.
Okay, okay. So the motion is carried. Correct? Thank you very much, everyone.
Sorry, through the chair, just
Yes.
so we're really clear, that does not prohibit community engagement
Yes.
on this.
Oh,
Just so we're
absolutely
really
not.
clear.
Absolutely not. We've got all our publicly and phone numbers and it all depends who comes in, of course. We're publicly available any time. Phone numbers available. And you've got my reasons for just deferring this. I'm not against it at all, but I just defer it for too much misinformation out there. So the motion is carried. Thank you, members of the public, and thank you for your time and indulgence and listening to us debate. I will now adjourn the meeting for a quarter of an hour, and we'll come back and we've got quite several items to go through. Thank you very much. Okay, we are ready to roll. Thank you very much for everyone's indulgence today. Nice to see everyone back. Karen, we're item number 5.2. I believe 5.2, which is, we live screening again, or we're uploading? Yep, cool. Thank you very much, Karen. Okay, right, adoption of the Water Services Delivery Plan. And lovely to see Joe here. He's been working very diligently on this, and Mr. Tony Hale here this afternoon. And Joe Walton is our program manager for this project. Joe, I'll hand over to you, or Tony, do you want to? Okay, right, the floor is yours. Thank you.
Thank you, Your Worship. Kia ora, Councillors. We're here today to hopefully adopt the Water Services Delivery Plan and present it to you for your consideration. This document is the culmination of almost a year of work. I was reflecting today that we and many other councils submitted on the original bill that we would need 2 years to complete this work. However, we've managed to do it within the time frame. So, as you know, there is a legislative requirement to deliver a water services delivery plan to the Secretary for Local Government by the 3rd of September. Recent guidance from the DAA suggests that acceptance decisions on those plans will be made by the end of December. This council has already done the hard work in the decision making with the big decision that was made on the 24th of June on the future delivery model for water services. By deciding at that time on the delivery model of remaining in-house, that decision has set the direction of the water services delivery plan content. It is a large document, but what is laid out in the water services delivery plan is essentially an operations manual or a how-to stemming from that decision. It's all of the information that's contained within it is essentially what was already contained in the long-term plan, the annual plan, the infrastructure strategies, asset management plans, and finance strategies, as well as some performance measures from the annual reports. So there's not actually that much new information contained within there. It's essentially just gathering up of all that info we already have. We've followed the DAA template, so I just want to comment that we did leave all of the guidance in the document that you see before you. That was intended just so you had context for the criteria that the document is required to contain, and just to give some reassurance that we have met all the requirements of the plan. Just want to also point out that DAA has already seen this draft plan, or a version very close to it. They gave us feedback earlier in July, pretty much accepting, generally as stating that our plan appears to meet all of the requirements of the Water Services Preliminary Arrangements Act. They did request that we add some additional information, which we have since done, but this was primarily information just to support the fact that we are meeting the investment sufficiency requirement. But they did not see any financially sustainable issues. They think we'll be able to meet all that criteria. We've also received external assurance from WSP on the plan, and again agreeing that we meet all the financial sustainability criteria. And that is kind of the technical. I just wanted to cover some of those technical points of the plan. Happy to take any questions. Tony was just going to cover a few extra points about what the implications of the plan are for council.
Tony Hale.
Thank you, Your Worship. Look, I'm going to probably echo some points that I've made previously at various other meetings that we have had. You know, a huge amount of work has gone into this from the team, multi-organisational input, but also yourselves, elected members. You have been at multiple workshops and you've done a lot of hard work yourselves. There's thousands and thousands of documents that you've read and seen, and certainly I would say that the Water Service Delivery Plan is a really good stocktake of where we're at. Gives a good picture of our position to deliver high quality, financially sustainable water services. Question is, what's now? What's next for us? Well, look, the implementation plan is probably one of the main large crucial areas, and basically it's not status quo. I just wanted to label that point. And that we've got many work streams that we've got to perform underneath the implementation plan, so the work doesn't stop, it continues and will for some time. So we're going to be starting looking to prepare and working on the implementation plan, subject to your approval this afternoon. We'll be looking at obviously how we, what the governance arrangements we put around this. We'll be looking at ensuring that we have the financial separation that's required, as well as information disclosure. So you have a recommendation on the table. An awful lot of hard work has gone into this, and we are happy to take any questions that you may have.
Thank you, Tony. Okay, I open the floor up. Councillor Lachlan, who's first?
Oh,
Councillor Williamson.
Through the chair, unless Councillor Lachlan has actually a question. I don't have a question. I'm just going to make some comments.
My question.
I'm next. I've got some questions. But first of all, I was, blown away with the amount of work that you have done since you first started this process, which was sort of not long after we came into the triennium, having to dump the three waters of the previous government and then go and look at something completely different. Not only that, the whole consultation process that you had to go through with Waikato Water Done Well and all of the stuff that went to it. So I have read this document really, really carefully. I haven't checked your figures. I'm sorry. And I'm not going to. I'll take them as believed. I just want to say it's an amazing document what you've actually done, and I suppose in some ways it's probably a little bit aspirational as well too, because I can see there's a lot of stuff that's actually going to take up your time going forward, and I'm thinking particularly about the business unit and taking it out of there. There's just a couple of little questions I want to ask you. On page 90, we have got a comment there about unforeseen events, most likely natural disasters, flooding, volcanoes and earthquake. I would just challenge your opinion on REA. I would say that certainly as far as flooding is concerned in our district, I don't think that's rare, and so far we're pretty good, but lots of our district is actually in a flood zone. And of course we've had Cyclone Gabrielle in the last couple of years, which, all of that stuff that's going on. Just a comment really, I just challenge you over rare. I don't think rare is the right comment that we've got in there. I'm just flicking through to get my other questions while I'm here. I wanted to ask you about Hatepe. Right on the lake has no wastewater scheme and none planned.
Oh, through the chair, yep, you're absolutely correct.
Yeah. And you don't think being right on the lake that something for Hatepe in the way of wastewater would be something we should be looking at? No?
Well, certainly, there's, when I think back to some of the water reforms, and there was a dedicated group via Te Mata Arawai who were looking at some of those rural communities. Yeah. And certainly there was, it was looked at to try and provide servicing. Yeah. And then and I know that we've done some studies on those eastern townships. There's a few down there, several. Yeah. And whether that's something we look at through the LTP process, certainly you're quite right, there's nothing at this moment in time.
No, thank you for that. You just said it seemed a glaring one. And the other thing we're talking about, Tūrangi, page 95, in and I've always been aware of this, a very, very large loss of water through the pipes there. So you're currently putting in new water pipes right through the Turangi township. Are we hoping that that will alleviate this problem of this massive loss of water?
Well, any new pipes, sorry, through the chair, any new pipes will obviously be a lot more watertight than some of the old ones. And look, honestly, with some of our assumptions, we believe that a significant amount of leakage is on private pipe work as well. And obviously that's difficult because we don't have volumetric metering across the district. And but there are things that we can do and that we will be looking at as we move forward and around demand management.
So when the new pipes go in, Tony, there will be a meter going on. I mean, we're not using it for charging, but there will be a meter going on to properties with the new pipes.
We certainly, through the chair, we certainly put in the facility to install water meters.
Because we can pick that up if it's on private land then, can't we? And we can sort of get the private landowners to do something about it. Yeah, okay, all right, moving on. Hang on, just looking through my notes. And, the only other thing I was sort of, page 99, the assessment results on the spider web, I thought it looked a little bit depressing, to be honest. Are we not better than that? I thought we were very good.
So when the previous asset management plan was reviewed, there were some sections that we hadn't previously included, so that does have an influence on how that's displayed.
And you think this time next year the spider web will look prettier than that?
That would be something to get towards, and yes, I believe it will be better.
Thank you. That's all the questions I have.
Okay, next. Who's next? Councillor Lachlan.
I worked out my answer, but I want to also support Councillor Greenslade's corridor about the work that your team's done. I know you've been under pressure and under-resourced and understaffed and everything else in terms of this whole process. So I just want to acknowledge the good work of your team. But I've got no technical questions in terms of the paper.
Thank you, Councillor Lachlan. Deputy Mayor.
Or not? No, go, John.
Thank you, Your Worship. Yes, all I can just endorse the comments made by Sandra and Danny's regarding the astonishing work that's done by Joe and Tony, all the team, to get this point. Is obviously also does demonstrate the high regard District Council held, just currently also historically with our infrastructure management, with renewals, level of service and growth. So just commend you all, and as being part of the working party group, steering group with Rachel and Kevin as well, being paid party to sort of the detail and the work you put in, countless hours you put in. I guess there's a few sleepless nights as well, dealing with DIA, etc., and the conversation around about going into group, into the CCO, things like that, So obviously, I'm just very happy to actually move the 3 recommendations as up on the board there.
Thank you very much, Councillor Williamson. Has been moved. Now more conversation.
Well, I'll second it.
Deputy Mayor, you're happy to deputy to second it?
Just a couple of comments. I don't have a question for the team. This agenda item comes on the back of one we agreed to at a previous council meeting around retaining our water services in-house rather than joining Waikato Waters as a full member. Coincidentally, on Monday this week, I was at Karapiro for the signing of that inauguration of the CCO for Waikato Waters. And although we are sitting on the side, they were generous enough to allow us to be a signatory to that. The only reason we can do this, and the only reason we've got this water services delivery plan to vote on today, is because of the outstanding work the Waters team has done over a significant period of time. And if they hadn't done that, and we hadn't invested as we have done over many, many years, we would be in the same position as a number of the mayors I stood next to on Monday, having no choice. We have a choice, and it's down to the work of Tony and his predecessors and the team. I see Tom back there, and Joe, thank you, and Sarah. Outstanding work, and I note an illustrious list of names of those who have reviewed this plan and given it the big tick across all disciplines, both finance and technical and so on and so on. So I think as a community, Taupo should be rightly thankful for the team we've got and the work that they have done. That doesn't exclude our CEO, who has spent countless meetings with her compatriots around the Waikato on Waikato Waters Done Well. So to me, this is a big tick item, and it's really cool to be in this position.
Thank you, Councillor Taylor. You were happy to second. Any other commentary regarding the project?
Through the chair,
Councillor
I
Shepherd.
might as well round out the trifecta. I was the third councillor on the steering group, so I also know firsthand how much hard work has gone into getting this water services delivery plan together, not just so well, but also within the time frame, which, you know, we thought at one stage might be an impossibility. So just really want to acknowledge the work of Tony, Joe, Sarah, Tom, the others in the Waters team, and our CEO, who also managed to do very well for us with the shared services and procurement agreement. So thank you for that.
Very good. Complimentaries all round. Councillor Campbell.
Through the chair, I was just going to briefly speak against the motion, but I think we wait till after when we... Should I say it now? Or
it's been moved. Who moved it again? Yeah, moved by John. Seconded by the Deputy Mayor. Do you want any speakers against the motion?
Yes, Your Worship.
Councillor Campbell.
Yes, very briefly. Look, I'll make this very brief and no disrespect to staff, but if these council chambers weren't such a, and I'll try to put very politely here, very, very much less than model of democracy, I would have been given opportunity to express my own views in the so-called final debate on 24th of June, I think, which lasted all of 20 minutes. And that was that I believe a well-constructed CCO would probably have a better chance of being transparent and accountable to ratepayers and elected members than the current untransparent and opaque arrangement that, as far as I can tell, is largely set to continue with this recommendation. Thank you.
Thank you. It's been moved and seconded. Anyone else want to speak against? No? Could I put the motion, please? And thank you. The complimentaries have gone all round, and especially to the staff for such a fantastic outcome. And I think it's complimentary of our predecessors sitting up on the wall there that have never deferred maintenance. They've always got on with the job, always kept our product up to standard, so I think it's fantastic. Could I have those all in favour, please? Aye. Aye. The motion is carried. Thank you. Would you like your against recorded? Okay. Very good, you got that, Karen. Okay, moving on, we have item 5.3. Billy, he's been waiting a while. Change of classification of part recreation reserve in Kinloch pursuant to section 24 of the Reserves Act 1977. And we've got Billy V and Tom and team here this afternoon. Sorry, have I got the right one? Yeah. Jason, correct? Okay, Jason, how are you? Sorry, your first time caller? Yeah. Good to have you here. You've come to a doozy, haven't you? Infrastructure Project Manager, and Thomas Swindells, wonderful Tom, who's been here with us for a number of years. The floor is yours. Billy, you want to start out?
Through the chair, thank you, Your Worship. Well, you've said it really. Billy V, Parks Advisor, Tom Swindells, Three Waters Asset Manager, and Jason Dane, Infrastructure Project Manager. So this agenda is for elected members to consider reclassifying part of a recreation reserve located on Loch Eagles Rise in Kinloch. The reserve was vested in council as a development contribution from the residential developer and is formally classified as a recreation reserve. It's made up of a walking track linking to the Loch Eagles Loop track and is well planted with a mix of native and exotic species and a sealed car park. Council officers are tasked under the 2021 long-term plan to construct a new water reservoir to service residential areas in Kinloch. The procurement of land to construct the reservoir has been an ongoing obstacle, and given the limited suitable sites available. The reservoir needs to be built at a specific elevation to ensure properties can be gravity fed, and sites considered prior to the reserve met these requirements, however was not obtained for this project. The reserve's recreation classification restricts the activities on the reserve to that of a recreational nature. So by reclassifying part of the reserve to local purpose utility, it would permit the construction of the water reservoir on the reserve and aligned with the Reserves Act 1977. So under the Act, there is a process to follow. Starting with the meeting today, should elected members agree in principle to reclassify part of the reserve, public consultation is required, and that would begin Thursday 7th of August and conclude Sunday 7th of September. We'll have a public notice printed in the local newspaper and posts on council socials inviting submissions from the public about the reclassification, and then a deliberation report of the submissions will be produced for elected members to consider the final resolution at a future council meeting. So the engagement team informed the Kinloch representative group of this matter and engaged with surrounding properties through various methods of engagement, including door knocking, letter drops and emails. The feedback was generally positive, but the team will continue to engage with Kinloch residents about this project throughout the consultation period. So I'd like to inform elected members that the design of the reservoir will be consulted at a future date. This process is just to consider reclassification of part of the reserve for the purpose of constructing the reservoir. I'm happy to take any questions.
Thanks, Billy. Thank you very much. Any further commentary, Tom? Or no, all good?
Well, through the chair,
Councillor Campbell.
Yes, it's a brief suggestion. Question/suggestion. I mean, not everyone reads the local rag. Had you thought that perhaps putting some little, I don't know, people walk through there, putting some little signs, temporary signs there, we're doing a consultation, if you want to know anything, call this number or something. Sound like a good idea?
Cool. Very good. Any other questions? Unfortunately, it's got to this stage where we've got a reserve. We couldn't agree with, obviously, private landowners, which is understandable. Prime land out there. Councillor Lachlan.
I'm happy to move when you're ready, Your Worship.
Very much, Councillor Lachlan. Yeah, thank you. No other questions of the team? Thank you, Billy. Thank you for waiting for so long, team. Moved by Councillor Lachlan, seconded by Councillor Taylor. All those in favour, please say aye. Against? Carried. Thank you. Next up, we have item 5.4, selection of a Development Contributions Commissioner for pursuant to 173 Lake Terrace. Aidan.
Thank you. I'm just filling in for Philip. You've got the paper. I'll just give you a quick reminder of what this is about. It's really just an administrative matter. People have the right under the Local Government Act to object to their development contributions charge under certain grounds. That objection is then heard by an independent commissioner who makes a decision which is binding. So council's role is to appoint and facilitate the commissioner. We've got an objection, so we're seeking your decision to appoint that commissioner, and also delegation just to administer that if we need to change. So I'm happy to take any questions, otherwise you have the recommendation.
So Aidan, any questions of Aidan? Councillor Taylor.
No. Yes. Just one. I know the paper talks about whether it's our policy or whether it's the legislation talks about commissioners plural, and because this is a relatively minor matter, we're just going with one. Are we on solid legal grounds in that respect if we just go to one and not open to challenge in that respect?
Yes, that's right. We're to choose up to 3 is what the legislation says. So certainly for a simple matter like this one, it's a small amount of money. It's a reasonably simple debate around the definitions and whether or not Airbnb fall into the sort of temporary accommodation category. So we think one commissioner's reasonable, hopefully also cheaper and faster for the person who's got the objection.
I didn't read up to 3. I thought it was 3.
No, it's up to 3.
Up to 3. Sorry, my misreading. Thank you.
Thank you, Councillor Taylor. Any other questions, Baden? No. Fire ahead. Councillor Campbell.
Yeah, look, my apologies if I didn't read this carefully enough, but no, I was interested in the grounds of objection. You mentioned Airbnb, as in.
Yes, it just comes down to debate on how we've determined the type of development and whether or not which definition it falls within the policy. So they think we're not applying the right definition. We think we're applying the right one. The Commissioner will resolve the answer. So it's not a high risk matter. There's no particular impact on Council either way, and hopefully we can do this smoothly for the objector to resolve the issue.
Thank you, Aidan. Councillor Greenslade.
Lost it. It was through the chair. Just an operational question. Is it 75,000 per lot or 75,000 for the 3?
No, that's for the 3. So their position, it should be 25. Ours is 75. The difference is the 50.
Thank you, Aidan. Makes sense. Just keep it at 1. I think, as you say, it's reasonably minor. And you've got a commissioner in mind? Sorry, did I see the names there?
Yeah, we've identified the local commissioner. She's based out of Rotorua.
Yeah.
She doesn't have experience in these. In fact, not a lot of the commissioners do because there aren't a lot of objections. But she's very familiar with the Act. She's proven she understands what she has to do. And we think she'll be efficient and get it done.
Cool. Thanks, sir. Yeah, okay. Happy to move?
Oh, through the chair.
One last question.
Sorry, I apologise. I don't have any problem with the commissioner selection, but it's just to satisfy my curiosity. Is the contention that? What is the contention that we're saying that these are Airbnbs and they're denying it, or sorry?
The contention is whether or not it should be the Airbnb buildings that have been built bespoke for that purpose. They're rather large though, and the contention is should they be treated as a temporary commercial accommodation unit, which is typically a motel unit, or as a standard residential house. So that's the contention. It's not very well defined in the policy, so we'll see what the Commission makes of it.
Good. Great. Happy to move. Councillor Shepherd, thank you very much. And seconded by Councillor Lachlan. Thank you, Aidan, for your concise delivery again. All those in favour, please say aye. Those against, carried. Right, next up we have 5.5.
And next up you have a surprise because this is me.
Unfortunately,
unfortunately, Tanya is away.
Ladies and gentlemen, Julie Gardine.
I am not Tanya Russell, and unfortunately Tanya Russell is away ill today, but this is simply a paper to provide you a copy of the final statements of intent for your council-controlled organisations. So happy to take any questions, but it's simply for a receipt.
Receipt, pretty standard procedure. Any questions of Julie? No? Could I have a move, please? Thank you, Councillor Lachlan. Seconded by Councillor Fletcher. Thank you. All those, was it? Sorry? Yep. Yeah, thank you very much.
Sorry, Councillor
Kylie. Come in, Kylie.
Has that been moved?
Yes, it has. Moved by Councillor Lachlan, seconded by Councillor Fletcher, but you're most welcome to have a question or anything.
It's just a comment. I would just like to reiterate letters of expectation for these organisations following this statement of intent would be a very sensible and practicable way of expressing what we're wanting from them.
Yeah, Councillor.
I have suggested this before, but I would just like it officially recorded.
Cool.
Firstly, just my apologies for jumping in there, Councillor Leonard. Yes, we do provide letters of expectation, as you've asked previously. We do that in the beginning of the process so that they take that into account when they're formulating the statements of intent. So, yeah, we have taken on board your recommendation.
So do we see that as a group? Sorry if I missed something here.
Yes, you do. You have provided the opportunity to put input into those letters of expectations. It's just at a slightly different point in the process.
Thank you.
Well, good. Thanks, Kylie. Good to hear from you. Hope you're all good at wherever you are. All right. Okay. Suggested recommendation there has been moved. Lachlan, yeah, and seconded by Councillor Fletcher. Sorry. Karen, is that all right? Yeah. All those in favour, please say aye. Against? Carried. Right, 5.6.
Surprise again. So this is the monthly council performance report, and you've got me again for this agenda item 2. It's a normal process to provide you our normal council performance report on a monthly basis. This time around, it is the end of the financial year, so in June we typically don't provide you the financials because we're working on the annual report, and that's the case this year. A couple of things that I'll perhaps just highlight for June. As you well know, we've had some big milestones come through the council meetings during that period of time. First one I was just going to mention following today, not too surprising, was around your decisions on water services, which were undertaken. We made that call in June. It followed a large amount of work for councillors and staff, so that was a big milestone. The annual plan adoption, and also just highlighting in the performance report this month, it talked about the flooding event, or the potential flooding event that occurred in June, particularly in the Taonga Taupo area, and just want to highlight that, from my perspective, that actually went very well. And we'd taken on board a lot of lessons from an event that occurred in February up here. So thanks to the team that jumped into action for that event. And we've just had some staff go down actually to Nelson, Tasman. So it's great that we've got some skill sets that are being called on across the organisation. And I know I'm going to steal Panel's thunder once again, but just really highlighting that CapEx plan this year, as we can't recall the last time this occurred in the organisation, but this year, never, okay, so that's why we can't recall it. So this year we've actually been able to deliver more than what we planned in terms of CapEx delivery, so we've been quietly celebrating that internally as well. So I'm sure Panel will provide more detail on that, but that's a big milestone for us as an organisation.
Great, thanks Julie. Panel. Good afternoon, Panel.
Good afternoon, Your Worship, and everyone. Thank you so much for your ongoing interest in these projects. I appreciate you've had rather a large afternoon. I'll keep it brief. So just to reiterate what Julie said, this is quite a seminal moment for us because of our achievement regarding capital delivery. I can't really describe the graph for you, but it's on the up and it looks great. And I guess it's due to people like Jeanette's team and all of the people that have spoken today who really put a lot of mahi into delivering the projects out there in the field. And I know many of you are involved in steering groups, and I thank you for your guidance on that as well. So we're close to a 113% delivery against target. I don't know if that's exceeded in NCA terms, but so this is the transition, obviously, between the last financial year and the new. We are going to be phasing out a couple of projects on your regular monthly report as they're closed out and moved on, such as Southern Trunk Main. We also have approximately 10 additional projects that will be joining us over the course of the next few months. Obviously, we want to be able to have enough delivery and action to report, so we're just waiting for that moment when project managers are in place and things are happening on the ground. And this year it's going to be really exciting to see a little bit more in that, in some of those broader space, such as the Great Lake Pathway, Seacombe, Wariwaka Park, those types of projects where, you're going to be able to see some of the action on the ground. But for now, we're continuing to deliver a large amount of multi-year projects, so there's going to be a lot of continuity. Just really the key changes this month, we've got a decrease in the cost risk at OD Park as we've now signed the construction contract, so great work to that team. We have a small increase in the time cost regarding the Te Andanini Car Park delay, and that's largely due to the weather, unfortunately. I did actually check the Waikato Regional website earlier today, and we're about 40% above average rainfall in the last couple of months, so hopefully that will decrease soon and we'll be able to close that project out. I just wanted to shout out to the wonderful group who helped out with the community planting of the 4,000 gully plants for the EUL team at the end of June. I think that was very cool, and it's just great to see everyone getting in amongst that area. There's also, importantly, a decrease in time and cost risk for the SCADA upgrade project, which has been a lot of work in the wings to get to that point. and that's around the prioritisation work that we're doing with Mott MacDonald. And I'd also like to make a special comment regarding the Kuratau foreshore erosion control resource consent being lodged. Thank you for your time, unless there's any other questions.
Thank you, Pernell. Questions of Pernell? No, Councillor Greenslade, I knew you couldn't resist.
Thank you. Just, can you elaborate on the Kuratau? Where are we up to? What's the story with that, Pernell?
I'll just defer to Warwick through the chair. He's up to speed by minute.
Oh, Warwick. Xander.
It's flagging green there. So yeah, the update is essentially that we've lodged the resource consent. They have 20 working days to work through that process, but that's still in transit. Hopefully at the next meeting we'll have an outcome as to where that resource consent is at. But it's good news though.
Little cameo performance here. Very good to see you. All right, Pernell, anything else? Councillor Taylor.
Just a quick question. So, given the outstanding result, Pernell, does that mean our bow wave now turns into a ripple, or where are we at with that?
Not good enough to surf on, anyway.
Through the chair, that's a very good question. I guess the answer is that we're still working on that absolute bow wave number. We did great against that annual plan number. Sorry, carry forward's the correct terminology. And the, you know, obviously mathematically it's got to be lower. So that's really great news. Do you want to add, Jeanette?
We are hoping to have the carry forward proposal to you at the next council meeting, so we'll be working with the team. We've already done quite a bit of work, so we'll have that number to you.
Cool. Thanks, Jeanette. No other questions of Jeanette and Pernell? All pretty happy? Councillor Rankin, you're all happy? That's good. Councillor Deputy? Yep, cool. Okay. Councillor Lachlan?
I'm happy to see just a little question. So the end of year financials roughly looking all right, or just sort of?
I can't actually comment, Danny. I haven't looked at them. Sorry, Councillor.
Cool. Thank you, Jeanette.
I'll just jump in if I can, Mr.
Yes, certainly, Councillor Shepherd.
Mayor. I just want to acknowledge the really good work of the project team and the teams that have helped deliver the projects. But I just, from a project management perspective, I know how challenging that space can be, and there's so much out of your control. So to achieve 113% is quite outstanding. Thank you.
Just one more question, sorry, Your Worship. Warwick, on page 260, Parks and Reserves, what is the Seddon Oak in Turangi? Maintenance on the Seddon Oak.
Yeah, after Dick Snedden, I suppose. Seddon. Former Prime Minister, I presume.
I don't know.
Councillor, I might have to come back to you on that one. Yeah, I'm aware of the one that we've got in Taupō here, but not the one in Turangi.
Thank you, Warwick. Could you report back on that, please, Warwick? Detailed report, please. 50 minutes. All right, Pernell, sorry, 120%, Pernell, lovely, thank you very much. Great news. And Jeanette, the finances looking good, well, hopefully, which is great. So, any other questions of the CEO before I wrap that item up? No? Could I have a mover, please? Was it that long ago, was it? Sorry, Councillor Taylor. Seconded by Councillor Greenslade. Thank you very much. All those in favour, please say aye. Against? Carried. Was it a different seconder? Sorry. Oh, sorry, Councillor Lachlan. You seconded it. Yeah, you did indeed. Been a long day. All right, 5.7, Council Engagements, August 2025, Appointments and Training Conference Opportunities. We've got a resolution there, 1 and 2. Karen, are you telling us all about this? No deviations? No changes? We don't have to get legal advice from Nigel on this slot? No? Good. So 1 and 2 is we have a mover, please. Thank
Can
you,
I speak to
Councillor
Your Worship? Can I speak to it, please?
Councillor Greenslade.
I just want to say that the Turangi Co-Governance Committee workshop and the Turangi Governance meetings their times have been moved, as has the Grant Distribution Committee meeting, because the Assistant Minister of Health is meeting in Turangi at 12 o'clock on Wednesday the 6th of August. So just like to encourage anybody and everybody who's concerned about health in this district to attend that meeting.
Cool. So it's the co-gov committee is 9 o'clock still?
Yeah,
start?
we've moved. They've moved it. They've
They're
moved
all
it.
correct.
Yeah,
Okay.
in the afternoon we've got the grants committee, which was moved out from 1 o'clock till 2 o'clock because the minister is speaking.
Okay. Lovely. Thank you. Update, Councillor Greenslade. All right.
Through the chair.
Yeah. Yes, Councillor Campbell.
Yeah, while I've got the opportunity, I think it'll just be just a question really. There was much hoo-ha about the Local Government New Zealand conference last month, and we received hundreds of emails from the taxpayer union, sort of cut and paste jobs, questioning about the LGNZ. They call it the campaign against rate caps, and demanding to know who, which of us voted what. I mean, is there something we can? I know very little about what happened there, what it was all about.
Yeah.
I think an explanation about.
Cool.
Would
Was
be
a
in
remit. There was a remit on the table, correct, Madam CEO?
Yes.
Remit on the table. Do you want to explain it? But we voted for the remit to carry on with the conversation about the rates capping. You might like to elaborate.
Yes, I'm happy to speak to that if that's helpful. Councillor Campbell, yes, I agree. We do all receive numerous emails regarding the rates cap proposal, which has been discussed by government and also is being advocated for by the taxpayers union. Basically, in my view, what occurred just prior to the Local Government New Zealand conference, actually I think it was on the Tuesday and the conference started on the Thursday or something close to that, was the local government bill came out from government, and it was clear that the rates cap or the rates peg was not in that bill. So there's going to be two parts changed to the Local Government Act. The first one we have is a bill form and the second one is to come. It's likely that the rates cap will be within that second bill, which is yet to come. So at the LGNZ conference, it wasn't a remit, but it was a paper that was put forward for discussion at the AGM. And the discussion, I guess, was firstly, it was about local government advocating to central government around the rates cap. My read of the room was there's some nervousness, not because councils don't want to be efficient, but because they're very concerned about them impacting on core services. So when you think about your water services delivery plan today, it's very clear that we've got additional costs to come to meet central government requirements. What occurred at the conference, and I'm really happy for someone else to jump in if they believe I've got it incorrect, was an amendment to that paper. And it acknowledged that we simply don't have the information at this stage because the rates cap was not included in the bill that was released from government. They suggested that we meet again once the further information is available, and that was the end of the resolution that was passed. So my recollection of the outcome of that discussion was that there will be a further Local Government New Zealand meeting scheduled probably for early next year once we have additional information available.
Councillor Taylor. Yeah, you're on.
So it's not an agenda item, but it's ancillary. But I can just add to what Julie said. I was at the AGM where this item was tabled, and the tenure of that agenda item was that Local Government New Zealand and councils should work with central government on this issue, rather than setting up an adversarial environment where we're just banging heads together. So it was a collaborative, cooperative kind of approach, I think was the general tenure of what was being expressed.
No, well, through the chair, I mean, that sounds all very benign. From the sounds of it, you'd almost think the taxpayer union got totally wrong end of the stick. But But can we? Are we able to read that paper somewhere? Is it on the LGNZ website or something? I'd be interested in reading it.
My recollection, it actually came out in the LGNZ newsletters to members, but I'll have to confirm that.
Yeah, okay.
None of which has anything to do with this agenda item, just saying. But there we go.
Okay. Right, back to, and there's just number 2 on the resolution that we appoint the Deputy Mayor to the Waikato Waters shareholders. Are everyone happy with that? Yeah, cool. 1 and 2. Do I have a mover, please? Thank you, Councillor Lachlan. Seconded by Councillor Williamson. Thank you very much, John. All those in favour, please say aye. It's against? Carried. Is that it? Oh, then we've got to go into confidence now, yeah. Cool. So I'd like to move, ladies and gentlemen, to confidence. Do I have a mover, please? Thank you, Councillor Lachlan. Seconded by Councillor Shepherd. All those in favour, please say aye. Is against?